Good morning. Welcome to our conversation today. We are hosting this webinar to have a discussion around what are the contents of the referendum bill and what is the future of constitutionalism as regards the impact that this same legislation will have as far as the sanctity of the constitution is concerned. On our panel today, we have Mr. Morris, who is the Mr. Morris, who is going to be guiding us through the current political landscape in relation to the referendum, the BBI process, and what needs to be done as far as securing the sanctity of the Constitution is concerned. We are also joined by a panelist by the name of Philip Gishana, who is a Future Leaders alumni and also an advocate of the High Court of Kenya with experience in relation to constitutional and constitutional affairs. Without further ado, I'd like to invite Ms. Pauline Vata, who is the Executive Director of HakiJamii, to make the opening remarks as we intend to engage in this discussion. Thank you. Pauline?
Good morning.
Yes, Pauline, good morning. Please proceed.
Good morning, everybody. How are you? Thank you very much for joining us once again. I hope you've had a good start to the week. Today, HakiJamii, as always, we are here for another webinar on the Referendum Bill 2020. We seek to engage all of you to give us your input on what you think of this bill, and especially on the impact it will have on the human rights landscape in Kenya. Is it a good direction for us to have a referendum bill? And this should also be connected to the BBI process. I know all of us are eager to engage during today's discussion. We have able panelists who are going to guide us through and through during the session, and we look forward to your inputs, and we also look forward to you guys giving us more inputs and also more thoughts to guide us in shaping a memorandum. After this process, we will submit a memorandum to Parliament on some of your thoughts on the Referendum Bill 2020, but we also want an open and candid discussion because for very long, socioeconomic rights in Kenya have not been implemented. Now we are having talks of a referendum. So will those be touched? Will socioeconomic rights be different in Kenya if we have a referendum bill? Will it be different with BBI? Because remember, socioeconomic rights, Article 43, is the core and DNA of human beings. It's the right to food, it's the right to housing, it's the right to social protection, it's the right to healthcare. And so with all these bills coming into place, will it be different? We know socioeconomic rights are progressive in nature. And so will such a political bill change how socioeconomic rights are implemented in Kenya for the better, or will there also be clawback clauses that will be introduced? So we just need to be vigilant. We need to engage. This is not just an issue of civil political rights. It's not just an issue of the electoral process, because I know that's where a lot of attention is being drawn to with this bill. I can tell already the underlying connotations or the underlying voices that this is about electoral injustices. We need to fix this, but we also need to remember it's about socioeconomic rights injustices that to date has still not been implemented. Even with the COVID pandemic, we have very slow traction in implementing socioeconomic rights. And this is when government is actually realizing without implementing socioeconomic rights, then you don't have a public or a citizenry that can respond to a pandemic, because you need a home to stay home and to stay safe. You need clean water. You need good healthcare facilities to be treated. So these are actually the core of us human beings being in existence. And so as we engage, we need to take into consideration these factors. And we also look forward to having different thoughts and different ideas coming into place. So thank you very much for those already online. We look forward to more participants coming in, and I also look forward to hear from the panelists and from my colleague Kiriba, who has organized this. And thank you also to Lawyers Hub for giving us this platform. So wishing you fruitful engagement and fruitful discussions in the next couple of minutes and in the next hour or so. Thank you very much.
Thank you very much for that very deep introductory remark, Pauline. I think we are very clear on the fact that Article 255, as read through 257, is very clear on what would require a referendum. And as rightly put by my colleague, issues of human rights and the Bill of Rights are actually some of the key issues listed as issues that will require a referendum. And as we gear towards a 10 years anniversary of the Constitution, how far have we come as far as the implementation of the already adopted legislative framework, which is our Constitution of Kenya 2010? How far have we come as far as the adoption of that is concerned? I want to give our panelists a minute to just say hi and introduce themselves very briefly as we get into the discussion shortly. We start with Maurice. Good morning, Maurice.
Good morning, Peter. Thank you for giving me this opportunity. Yes, my name is Maurice Odhiambo. I'm an activist, also the chair of the East African Civil Society Organizations Forum Kenya, and also a consultant in governance and human rights. And I'm happy to be part of this discussion.
Thank you very much, Maurice. Philip, kindly say hi to the team as well as just a brief introduction as we get into the discussion.
Good morning, Peter. Good morning, everyone.
Good morning,
My
Philip.
name is Philip Nyakundi Gichana. I currently work for Transparency International. I'm an advocate of the High Court of Kenya and an alumni of the Future Leaders Connect program and an enthusiast for good governance. Thank you.
Right, thank you very much, our very able panelists, for joining us, taking time to support this engagement. I would like to just give a brief overview of how we would want to conduct this webinar. Ideally, I will personally drive the conversation as far as the content of the bill is concerned and what are the legislative proposals that are being made as far as the Referendum Bill 2020 is concerned. I have made an analysis in relation to some of the gaps that we have identified, and I will also submit the same to plenary for discussion in relation to what are the few or many gaps that have been identified within the legislation and what can be done or what ought to be the legislative provision as far as the conduct of referendums is concerned. So I will then invite Philip to speak as to the legislative gaps around human rights and the legislative gaps within the legislation itself, and further invite Maurice to create a linkage between this particular legislation and the BBI initiative, as well as just creating a link towards the human rights perspective. What needs to come out very, very strongly as far as a legislation that would have the bearing of changing our constitution is concerned. Without further ado, I would like to run my presentation on the content of the legislation. So ideally, what we want to understand is what exactly is being submitted as a proposal in the Kioni bill. Is my video on? And what is a referendum? I think it's generally defined as the vote by an electorate in response to a political question, which requires the citizenry to make a direct decision. We've actually had history of just one referendum in Kenya, which was leading up to the build up to the 2010 constitution. So ideally, the Kenyan citizenry had to make a determination as far as whether or not they want this legislation to be the supreme law of the land. Why is this an important thing to happen in a country, in a governance setup? Ideally, we look at it from the context of the laws are made for the people. And as such, the people should have an avenue to review, to improve, to repeal, or otherwise just customize the legislations to fit the aspirations that they want. And the Constitution of Kenya actually notes the supremacy of the people as a key decision-making organ in the country. So it creates an opportunity for the electorate to accept or reject propositions that will have a direct bearing on the social contract, ideally the rights and duties and responsibilities of the parties in a governance situation. The Constitution of Kenya 2010 had made provisions in relation to how it ought to be reviewed and what are the key requisites for a referendum. This is actually covered with, through Article 255 to Article 257, which guides the list of issues that would require direct decision-making by the people. Ideally, Article 256 talks about a referendum by a parliamentary initiative. Article 257 talks about a referendum by a popular initiative. Ideally, the difference is, of course, the parliamentary initiative means that the referendum the referendum question will come from either House of Parliament. And the 257, a good example is the recent Punguza Mzigo initiative by Ekuru Court and the Third Way Alliance, which ideally sought to get a people-driven initiative, a people-driven referendum as in regards to a popular initiative requiring 1 million signatures, which they were able to collect and submitted for approval to IEBC, which verified and submitted the same question to Parliament. Ideally, through a popular initiative, the IEBC will be charged to verify the signatures that have been submitted and also to submit the specific legislation to each county assembly for determination in terms of does it meet the threshold, does it really meet the aspirations of the people. So what the referendum 2020 seeks to do is to give life to Article 255 to 257 by becoming an act of parliament, giving guidelines for the procedure for approval of amendment of the constitution by a referendum, how the said referendum would be conducted, and also introduces a very interesting aspect of petitioning the outcome of a referendum and for all connected purposes. It seeks to amend the legislative proposals given in the Elections Act on matters relating conduct and management of a referendum and for connected purpose. The object of the legislation would be to provide for approval of the amendment by way of a popular vote, how such popular vote would be conducted, and the procedure for petitioning the outcome. So as with any other elections, the IEBC will actually be charged with the question of verifying such voter register and making provisions for voter register, making provision for the voter register to be utilized within the referendum process. The bill empowers the commission to draw the intended amendment. For instance, if the submission is made by way of either the parliamentary initiative or by popular initiative, the idea is that we have a unified legislation that is going to be presented as the referendum question. So the commission is empowered to have that referendum question drafted either in consultation with the Attorney General or in consultation with Parliament. Of course, if such question is not properly or well framed by the person who is seeking to push the referendum. As we had mentioned, of course, the IBC will verify these signatures that are supporting a popular initiative. And then within 90 days of the receipt of the bill, the county assemblies are to review that particular legislation and see whether it meets the threshold. Of course, the determination would be whether or not counties are making an adoption to the said proposal, or they would be seeking to make some further amendments or approve it in a different manner. In most cases, we have seen through the Punguza Mzigo initiative, we've not had a very clear outcome from counties, with some rejecting and some adopting, but that is the provision in the Constitution. And this is what this bill is trying to bring out. The county will have to communicate such decision to just a minute. Okay. So counties are mandated to communicate the decision as far as the proposed referendum question is concerned to Parliament within 3 months of receipt. And the threshold for such adoption is a simple majority of the county assembly. with the bill setting a minimum of 24 counties adoption for the amendment bill for it to be submitted to Parliament for consideration as a referendum question. Upon which, if the bill that is submitted does not necessarily go beyond the provisions of 255, Article 255 of the Constitution, which highlights the list of issues that would be put to a referendum question, then the bill, if approved by both houses of Parliament, will become an effective amendment to the Constitution through as an act of Parliament. However, if the consideration up for the questions up for consideration are actually within the ambit of Article 255, the demand is that then that question has to be placed forward for a popular vote by way of a referendum. And just to bring in that clarity, Article 255 talks about any issues that are going to be standing for review will be subject for referendum if they relate to the supremacy of the Constitution, touch on the territory of the country, the sovereignty of the people, national values and principles of governance, and Article 10(2), of course, the Bill of Rights, which is our key area of interest, and the term of office of the president, the independence of the judiciary and the constitutional commissions, and the independent offices to which Chapter 15 applies, the functions of the legislature, objects and principles and structures of the devolved government, or the provisions of Chapter 255. So as far as making a recommendation for conduct of the referendum, the bill places this responsibility on IEBC, which shall within 90 days of receipt of such notice of adoption by the requisite counties and the Parliament, or instruction by President. We make reference to instruction by the head of state under Article 256, of course, guided by the fact that some of these questions that have been sent for parliamentary adoption might be within the ambit of 255. And as such, the President cannot assent to an approval by Parliament without submitting the same question to a referendum if it falls within the Article 255 provisions. IEBC shall assign a symbol for either response of the referendum question and publicize such symbol in print and electronic media. This is generally saying that if you agree or you reject the proposal, IEBC will be very clear as to which symbols you will adopt to communicate such agreement or disagreement. And within this notice, IEBC has to communicate the details of the referendum question, highlight the symbols and the date and period for the campaign, and as well as the polling stations and polling time. The Commission shall suspend registration of voters upon issuance of the referendum notice. So ideally, we want to have a compiled voter register that can be accessible prior to the referendum process and during and even after. So there will be no continuous registration of voters during this period. And for the purposes of clarity, the response to every referendum question will be a strictly a yes or a no issue, whether you agree or you disagree. Of course, the Commission is charged with acting in all manners to support the execution of the referendum vote. So ideally, it is empowered to appoint all officers required to conduct the referendum, design the polling stations and voting mechanism, as well as utilize facilities at no cost if they so elect to gazette them as centers for the poll. And the Commission is also empowered to set up access for members or parties who are seeking to participate either by accepting or rejecting or just as monitoring the referendum to form part of what is suggested to be the referendum committee. So ideally, all parties, political parties, individuals, faith-based organizations, civil society organizations interested in monitoring of the process ought to be admitted into the referendum committee. So each party to the referendum committee will nominate its own agents and second them to each polling station and tallying center for purposes of verification of the process. And the Commission shall make provisions for admission. Of course, this relates to also access to some of this information that is within the process, the forms, the vote, verify the process, the register, how the process is concerned. So the bill further makes a provision in relation to how can we challenge referendum outcome. So it grants this particular authority to directly to the voter, any person who is a legitimate registered voter, either who participated or did not participate in the process, and also the commission itself. It highlights some grounds for referendum petition, including misconduct during the process, corruption in acts or omissions impacting the integrity of the process, errors on the face of the record as far as the results are concerned. The petition is supposed to be heard by a 3-judge bench appointed by the Chief Justice. And if it makes further provision that if such results are not contested within this notice period, then it will be termed as conclusive. And if the notice lapses, then such results will be deemed as final. A petitioner will seek to serve the petition within 7 days of making such petition, and is also obligated to gazette the petition in the Kenya Gazette within 14 days of petition, and also in 1 local day. The courts are supposed to develop practice regulations as far as practice provisions for, and as well as practice directions, as well as provisions for security for costs in regard to conduct of electoral petitions specifically relating to the referendum. Such petition is supposed to be heard and determined within 6 months in open court, and the court will still have power to summon witnesses and call for examination of the votes. So thank you very much for following through. Ideally, that was just the opening session of this engagement, where we've been able to successfully just review the legislative proposal and go through the contents that it is trying to seek. So I would like to invite Philip to give a joinder as far as the legislative proposal is concerned, and what impact it would have on constitutionalism and the sanctity of the Constitution moving forward. How may it affect sanctity of the Bill of Rights, and what are the gaps that he has identified through his analysis? Welcome, Philip. Hi, Philip, are you with us?
Hello? Yeah, Peter, can you hear me?
Can hear you, please proceed.
Yeah, thank you very much. I think you have given a very comprehensive overview of the bill. And as such, I wish just to pick up from where you stopped and just highlight a few things that under Article 256 or 257 of the Constitution, there are things the draft of our Constitution thought are very important, and sought to ensure that the threshold for that the amendment has to be higher than other clauses. You have highlighted, of course, the supremacy of the Constitution and the territory of Kenya, the sovereignty of the people of Kenya. You've talked. It talks about the national values as we envision them under Article 10 of the Constitution, even the Bill of Rights, the term of the office of the president, independence of the judiciary, commissions and independent officers, the functions of parliament as it is established, the objects, the principles and structure of the devolved government, and now even the provisions of Chapter 16, which is on the amendment of the Constitution. So therefore, I just like to summarize that a referendum is anticipated in the Constitution, but within the framework of that, what the ambit of the Constitution it provides for. So just to provide, the bill essentially, as you have highlighted, does not propose to amend the Constitution as it is. So what the bill essentially does is just to provide the procedure of how to do the same, the threshold, and even the timelines. And as such, I think I've been getting questions that is the referendum bill amending the Constitution? No. What the referendum bill is just trying to do is to provide a procedure of how that should be done and the various timelines. And as you've highlighted earlier, it's not like a new process. It is something that has happened. You've highlighted the Ukuru Aukot initiative of Punguza Mzigo. So that is something that has happened.
We seem to have lost you.
Something that has happened. Sorry, can you hear me?
Yes, we can hear you now.
Okay. So, of course, the bill gives powers to the independent IBC, and it does not limit the fundamental rights and freedoms in as much as it's the broader framework it provides for. Of course, I will highlight some gaps where I found it to be problematic in terms of the Bill of Rights is concerned. But it does not concern, the bill does not concern the county government. That is in terms of Article 109 and 5 of the Constitution. As it does not contain provisions that affect the functions and powers of county government as set out in the fourth schedule to the Constitution. So I thought I should also highlight that. Essentially, national elections, which include the function of national government. I like to just say that it is a welcome move. In the past, before this bill, okay, we've never had really a legislation that talks about a referendum. We've always postulated that a referendum would be carried out in an election, which essentially is not a good practice. In an election, I think it's a bit more of a fight of popularity of individual candidates and political parties. And in an referendum is a fight for an ideology. So I think the two, when put together, shouldn't come out together as the same one and the same thing. So for me, the referendum bill is actually a relief that puts and sets aside these two, and as such, it to amend the Elections Act in as much as where the referendum was concerned. So for me, it's a good move. So I wish to make some specific proposals within the referendum bill as it is contained, that is highlighted. I think you've just put Peter highlighted Section 5, which it means that essentially the bill will just be passed by a simple majority of the county assembly by the members. I really don't have any reservations with this. It has been the practice, and I won't maybe want to go much into that. But on Section 7(1)(c) of the bill, it provides that the day on which a referendum is to be held, which shall not be 21 days after the publication of notice, the bill provides for a minimal time that a referendum can be conducted within 21 days after the date of the publication of the notice. To me, this seems to be a very short period and can easily be used to hold a referendum in a very short time, even if there are issues that probably should be interrogated and fast-tracked therein. And just to highlight that, to be clear, that once the bill is sent to the counties, they can discuss, they cannot amend the bill. They can only just debate and agree. If it just gains the simple majority, then of course the bill is forwarded to the two houses. And then Section 15 of the bill provides for a person intending to campaign for or against a question to be determined during a referendum, on application to the Commission, form one national referendum committee and one committee in every constituency for purposes of determining the referendum. I think there's need for more specification of this process of application and how challenging such kind of an application can be done. I think we know the people who control the politics in Kenya and the people who have the muscle to actually set up. And then Section 15 of the bill provides to actually set up a committee of such a nature. So if you are not among them and one committee in every, I think there's need for more specification of the application among them, and how do you also challenge those campaign needs to further clarify that area of forming such a committees. And then there is something that the bill talks about, that the committees shall not be given a name or a symbol for another political party or candidate that relates to another candidate. I think it's interesting here to know that the mischief is just trying to take advantage of the wave, that somebody can take advantage of the wave and ride, and especially right now, ride with the wave in the elections. I think the mischief usually comes after, that immediately after such kind of a popular initiative and maybe one will or a symbol for another political party or another candidate will form coalitions based on those names and based on those symbols. I think that is how the Orange Democratic came about, the chungwa symbol and all that. So I don't know how we could also tweak that to ensure that once those symbols are done from a referendum, there is no need for them to be carried over, because the ideology does not move from the referendum and move into political parties. Political parties are for purposes of elections. Quickly, just to move to the section 16, which talks about the referendum committees, that they shall be able to take care of this cause. I think this needs to be realigned as per Article 88 of the Constitution, which talks about IBC having the mandate of regulating campaign financing, and that IBC shall continue to monitor funds used in the campaigns. I think reading through the whole legislation, there is no talk about monitoring of the use of public funds during these campaigns for the elections. In the event that government chooses a side, how do we get government to be accountable so that they don't apply or use the resources they have to fund these campaigns? I think world over, if we look at even the cases of the Brexit campaigns, there were complaints after the campaign that what happened is that there were deeply going campaigns that were run digitally and overally to ensure that one side of it wins. I think there is also need for this kind of purposes, where we've seen already camps that are coming out to ensure that there is responsible use of campaigns. And even another example that comes into mind is the Russian one, where we were told that they were heavily incentivized that to vote in that referendum. One was given some reason to ensure that he votes the proper way. So there is also need to put also into this perspective to ensure that even as we run a referendum campaign, there is a clear and accountable use of resources in this. But as we look all through the bill, there is no mention of that. So section 31 provides that a referendum petition may be presented in the High Court. I think this one, Peter, you have highlighted in terms of who can bring this kind of petitions to the High Court. I think view and my opinion is that this provision seems to be limiting the persons or interest groups who may want to bring a referendum petition to the High Court. And as such, I find it is in contravention of Article 22 of the Constitution, which states that every person has a right to institute court proceedings claiming that the right or freedom has been violated or infringed. And they need to just either remove that clause, because we know who can bring such kind of a petition. The Constitution is already clear in terms of how that can be brought about, or just open up that list in accordance with that Article 2. And just lastly, from my end, I noticed Section 36 of the bill talks about the deposit of 1 million as a surety for a petition. I think this fundamental freedom has been violated or infringed. This is there's also need to strike a balance between the push for justice and frivolous litigations. In election petitions, I think we've seen a lot of people miss out that list in accordance with their valid issues they want to raise because of the issue of what needs to be deposited. I think there's a need to balance the balancing of the rights as enshrined under the Constitution, and also ensuring that we don't have frivolous litigations coming to the High Court. So, Peter, from my end, that is just the assessment I did and my opinions on the bill. Yeah. Over to you, Peter.
Thank you very much for that, Philippe.
Frivolous litigations are coming to the High Court. So, Peter, for
I mean, that was a very good analysis in terms of the gaps that are within the legislation. Of key import to me, just to do a small joint in relation to the limitation on the petition. There's also a question of mandatory gazettement by the petitioner, and we're talking about a commission as well as a private citizen. I don't know how many private citizens can be able to have to marshal resources enough to actually allow them to publish that kind of a petition within a daily, and also the Kenya Gazette as well. Philip has already very well alluded to some of the gaps in relation to discriminatory provisions around the petitioning. I would like to invite Mr. Morris, who is also another panelist online, to just bring in the link. I mean, what is the BBI line linkage to the referendum process and the referendum bill as it is proposed? And also, what are the risks to social justice? What are the risks to Article 43? What are the risks to the Bill of Rights as a whole? And the sanctity of the Constitution with the provision, if adopted as it is, what are the gaps and what are some of the opportunities we can actually address? So welcome, Mr. Morris, just to make your presentation and share your insight on that. Karibu.
Thank you very, very much, Peter, and thanks to Philip as well for both presentations highlighting what is contained in the bill. I made the efforts to plow through it yesterday, and of course I've heard what Philip has brought in terms of the gaps and so on and so forth. And I think my task, as Peter has once again explained, is to probably broaden the debate a little bit so that we begin to look at what this really portends in terms of linkage to BBI, linkage to the broader politics of the reform, if one believes that BBI is about reform, and or managing succession politics, if one believes that BBI is more of a tool for managing succession politics. I would want to agree with Philip that the bill itself only provides a mechanism and largely builds on the Constitution and provisions regarding referendum, which Peter also alluded to, Articles 255, 256, and 257. And largely, if you look at the bill, there are quite a number of things that are basically lifted from the Constitution. Again, it builds on what is provided in the Elections Act, I think Part 5 and some other there that deals with different aspects of the referendum. So again, there's quite a bit of cutting and pasting and so on and so forth. So secondly, I agree again that the bill ought to be in line with the Constitution, and the question here then is to what extent does it reinforce citizens' right to take part in elections, to take part in referenda, citizens' right to challenge, for example, by being part of petitioners, and so on. So I think there are quite a number of questions here that one has to grapple with as they look at the bill itself. I think I'd put together just a few things that perhaps I could add to what Philip has said before I start making the link between the bill and the ongoing politics, particularly on the BBI. And Philip alluded to Section 4.2, which talks about the commission. I think that was Peter. The commission being given power to edit. I think that's the language that is used when the a bill that has been presented to it perhaps does not adhere to required standards and so on. And the question there becomes, why not? Why doesn't the commission? Why shouldn't the commission be made to make comments and return that back to the formulators so that they themselves can have further input, so as to avoid any perceptions that perhaps the commission could be involved in any shenanigans. I think if you look at the politics of referenda so far, we've had a lot of suspicion. Whether you reflect back to Okoa, Kenya, and the exercise of verifying signatures, if you come to the Outcourt bill, the same suspicions have dogged these referenda processes, and therefore the need to make sure that this bill tries to really is formulated in a way that avoids as much as possible those kinds of controversies. I think there was, Philip might have alluded to 5.1 as well, county assemblies to publish in 2 newspapers of national circulation. That is once they have received the referendum bill. And by the way, again, it's good to have this distinction clear that what we are discussing now is a bill to facilitate the referendum, and later on we shall have the referendum bill, the bill that then will be taken to the referendum, a process that then will be facilitated by what we are discussing now. So the provision which requires counties to publish their referendum bill in 2 newspapers of national circulation. And the question here is, we might end up with a situation then where every county assembly publishes the same thing, and therefore they need to perhaps put this at a different level so that this publication at national level is actually handled at national level, and it can actually be handled by the commission. It is okay to propose that the county assemblies will publish in the Gazette because the counties, each county presumably has that facility. 5.2, does the mere, so I raised the question here whether the mere publication in Gazette and 2 newspapers satisfy requirements for public participation. And I think Philip might have alluded to that, that there is an assumption here that once you have published this, citizens will be able to read and so on and so forth. I think there is need here to perhaps look at some of the provisions under the County Governments Act, which allude to public participation, and try to see what then can be imported so that we have a wholesome process of deliberation and discussion of the bill at the county level. I think just to summarize my points on the bill, I think 5.11 I makes it possible, just the notes that I was writing here, for a bill to be sabotaged by opponents. Sorry, I can't quite remember what the bill itself says, but we can visit 5.11, and during discussions I'll be able to look at what exactly my notes mean on that. If you look at section 6, I think I noted that there's an assumption that the referendum will have a yes/no question. I've heard Philip talk about that. I think there are two points on this. One is the yes/no referendum, which is the direction we seem to be taking. But one would pose the question whether we could have a multiple question referendum, which then might attract a different way of thinking. I think, if we do this referendum the way we did in 2010, where the question was whether to adopt the new constitution or not, it seems to me as if this might not properly satisfy the requirements for citizens to actually scrutinize and engage in all the diverse and different issues that are likely to come up in the referendum. So those are the few issues I thought I would bring up in terms of the bill itself, and just to build on what Peter and Philip have spoken to. Now, let me see. I know that we had a meeting with HakiJamii where we discussed the politics of the referendum. Now, unfortunately, where we are now, we still don't have the second report of BBI, which basically means that our ability to engage with issues of context is a little bit of content rather is a little bit limited. So that is one point. The second point, which I think I should bring up before I go substantively into the matter, is that throughout the text of the BBI Report 1, which is now the only document we can still refer to, there is a language used that seems to suggest that we have adopted too much of a right-based approach and too much of a right-based language. So it seems as if there's an underlying assumption and feeling by the BBI team that ought to change. And therefore, broadly, even before one starts looking at issues of content, one must be careful that perhaps the philosophy and the ideology of the drafters of the first BBI report would want to have a situation where we begin to reduce, if you will, references to human rights and so on and so forth. And this is perhaps where the bigger concern comes in. But I will revisit that issue as we go on. Peter, I would like to just share the presentation, if you don't mind. And I know for you, it's probably a presentation that you have already looked at, and just very quickly look at some of the questions around the BBI process itself. Can you allow me to share screen, please? So because what the first point that I've made obviously is that there's the presumption that there's too much of the rights-based language, in the Constitution, and therefore the need to perhaps start looking at that. But there is also, of course, the allusion to the fact that some of the key aspects of the Constitution have never been implemented. For example, the BBI report, clearly the first report of the BBI clearly says that Article 43 as actually is one of the constitutional articles that has suffered because it has not been implemented sufficiently, and so those are some of the areas that one may want to just look at. So what I'll do is as I speak to the politics, I would just refer to some of the things that came out in the first BBI report, and just to state what the problem statement in the BBI report says. Kenyans have strived to build a great nation that is responsive to the urgent need for prosperity, fairness, and dignity, and dignity for all Kenyans. We have achieved a lot, but fallen short of our goals. That our people are crying out for leadership that shows the path to dignity, prosperity, and security. And so, see clearly, the BBI process seems to have had what one would say fairly good intentions, but then there's a possibility, as usual, that it might have fallen more towards the trying to resolve the politics of the moment, as opposed to resolving the issues that are stated therein. So what I'll do then is very quickly to remind you the 9 issues that were captured in the handshake communique, which are lack of national ethos, responsibilities and rights, ethnic antagonism and competition, divisive elections, inclusivity, shared prosperity, corruption, devolution, safety, and security. These are the core issues that the BBI team was mandated to look at. And therefore, the proposals that the BBI team made are supposed to address this. Now, I do not think that, I do not think that we will see 100% change in terms of the proposals that were made by the BBI. And very quickly, one of the things that I should bring up is that in the politics of the BBI, one of the prominent things that comes out is actually the need to share power. And this is an elite quest. It might only have, it might not have a lot of value for Kenyans struggling with high standards of living and so on and so forth. But it has a lot of value for the political class because politicians by nature are power seekers. So one of the key things that you find in terms of the recommendations is the need to expand the executive, and this has been the prominent discussion. And this still brings you back to the question whether BBI really is meant to address the problems that we have seen in that problem statement, ethnic antagonism, competition, and so on, or really this is just meant to provide opportunity for leaders to handle their own political squabbles. So that is really one of the key things if one is to look at the politics of the BBI. And so the question then comes again, if we go into this referendum, what exactly is in it for Wanjiku? And that's the question that this discussion is raising. If the issue is to increase, broaden the executive, what does that do for Wanjiku? If you remember the Punguza Mizigo philosophy was basically to reduce public expenditure. And here is a case where we are probably then going to increase public expenditure. So is Wanjiku, through the facilitation of the referendum bill that we are discussing here today, is Wanjiku then just being asked to legitimize things that may not be to their benefit? Now, apart from the issue of the executive, I think I want to highlight the questions around corruption. If one is looking at the content of the BBI report 1, this is probably one of the areas where one might want to say, fine, perhaps there is something there for Wanjiku, to the extent that we believe that the problem we have with fighting corruption is actually one of laws not being sufficient, which is many people will express a doubt on that. But let's see what that says. The report actually acknowledges that there are cartels and so on and so forth which have captured the economy. There's a lot of criminal activities going on, and therefore it promotes things around whistleblowing, which as activist organizations, we have always said we must have a whistleblowing law. We must have certain incentives in place for whistleblowers so that they're not targeted as has happened in the past. And therefore, what BBI once said is that 5% of whatever is recovered from corruption scandals should be given to whistleblowers. It says fighting corruption should be included as a performance contract of cabinet secretaries and permanent secretaries. I don't know how useful that is. That the ban of public officers, that public officers be banned from doing business. I think there it says public officers, and actually I doubt if it also says state officers, which is another discussion altogether. And it also says that open wealth declaration, so opening up the processes of wealth declaration, which since 2004, for those who have followed anti-corruption legislation, the wealth declaration regime has been a closed one, so that information is not available to the public. the need for individuals to explain any wealth beyond 50 million, and leaders to take responsibility when corruption happens in their dockets. Now, the reason I'm bringing this is just perhaps to, say, maybe there are things the BBI report 2 will bring, if the report does not change substantively, that citizens may then want to actually pay attention to and see whether these are things that can help with the transformation that we desire. And I brought out the area of fighting corruption deliberately to drive that point home. But again, it goes back to the question, shall we have a yes-no referendum, or shall we actually have a multiple question referendum? And that is one of the things perhaps I think even Philip might want to just reflect on. Let me say, as the final thing I want to say, let me speak to the question of housing, because the housing question was tackled to some extent, and I know this is HakiJamii's mainstay. So what BBI 1 did was to try to contextualize the questions around housing, but broadly also questions of implementation of Article 43. And clearly, the report itself comes out and says Article 43 has not been implemented. You can see, if you're watching the screen there, that the point number 2, under inclusivity, as one of the themes that BBI was dealing with at page 59, the report suggests that the problem of lack of inclusivity sometimes results from lack of implementation of constitutional provisions, such as Article 43. So clearly the report acknowledges that in terms of social and economic rights, including the right to adequate housing, the problem has been lack of implementation. It goes further under shared prosperity, which is the other theme in the report at page 68, to call for entrenchment of Article 43 in the following ways. That the national government is to develop policy and standards to guide implementation, that counties are to develop policy and standards to guide implementation in respect of devolved functions, that parties, elected leaders, election manifestos must include relevant policies around Article 43, which of course includes the right to adequate housing, and so on and so forth. So the point to make here is that the BBI 1 and hopefully BBI 2 shed some light on why some of these rights have not been realized, and that's the fact that they have not, the Article 43 has not been implemented. There's been lack of political will to implement, and so on and so forth. So I think, as I summarize, the questions that arise, if we are to look at the link between the referendum bill that we are discussing now, and as we go towards the actual referendum itself, is whether the bill we are discussing now then gives Wanjiku the leeway to actually get out of the BBI and the constitution amendment process things that will advance their socioeconomic circumstances, things that will help them to organize their livelihoods and meet their day-to-day challenges. If we look at BBI Report 1, we see that predominantly the emphasis is on things that are actually of benefit to the elite, increasing the size of the executive, and so on and so forth. But we also note that BBI 1 actually alluded to why social and economic rights have not been implemented. So again, the question becomes, is this process then adequately fashioned to enable the citizen to be in the driver's seat in terms of determining what will happen to Article 43, which has not been adequately implemented, and the other areas of human rights which also require to be sufficiently implemented. I will finish by just revisiting the point I made earlier. The caution here must be that because of the philosophy behind the BBI drafters, that we seem to have embraced too much of a rights approach, we must be very careful then to monitor, particularly when we have BBI to the report and then the referendum bill. We must really monitor and make sure that we respond adequately to any threats to the Bill of Rights, to any threats to Article 43, and particularly so as far as HakiJamii is concerned, the right to adequate housing. Ladies and gentlemen, thank you very much.
Thank you very much, Maurice, for that very elaborate joinder in relation to the political landscape and exactly what would be the intended and overall impact on the human rights space. As I can see, we've already started receiving questions in regards to today's discussion, and I would like to open this up. Kindly either raise your hand within the chat box or send in your written question and we can address it. And I like how both panelists have actually just brought out some of the gaps that are within this legislation. We're talking about a referendum with the possibility of having a multiple choice question. We want to address how can we conduct a referendum that gives the citizenry options to select from in terms of what are the things that we can choose option A as opposed to option B, as opposed to simply just having a yes and no referendum. And that's a condition that has also been adopted the world over. So just to throw it back to you, Maurice, there is a question directed at you, seeking to understand what stops the government from implementing these measures. Of course, you've brought it out very well that we have been, over time, seemed to adopt a very rights-based approach to implementation of governance issues. So the question is, what stops the government from implementing many of these measures suggested in the BBI, yet the Constitution provides them with the necessary framework to build on some of these issues? And of course, not with the expansion of the executive, but with regards to the other rights and responsibilities, including the general impact on Article 43. I will invite Maurice to take that question and just give a brief response.
Thank you. Thank you very much, Kariuki. Yes, I probably didn't go at length into that. I'm one of the people who have taken a position on BBI, and I've made that position fairly public in terms of this schism between BBI being simply a process to manage transition stroke succession, or BBI being a process that is actually meant to create a condition where Wanjiku, the burden on Wanjiku is lessened, Wanjiku's rights are enhanced, and so on and so forth. And that is why I brought the issue of the philosophy, the thinking that there is too much focus on rights as opposed to responsibilities. And even before I answer your question, even that is a very interesting conclusion, because BBI 1 report says we are too focused on rights. BBI report says Article 43, which is a critical aspect of rights, has not been implemented. So you see all that across this document when you engage with it. So what stops government from implementing? So one of the positions that must be very clear is that a lot of the issues that we have been talking about under BBI are already captured in the Constitution. And not just that, we've had so many different reports. If you start talking about land, for example, there's I think I brought this up in some discussion at the course, that if you look through the processes we have had in terms of formulating the land policy, a lot of the provisions in the land policy finding their way into the Constitution, the question of the challenges of land at the coast have consistently been addressed. The land policy itself actually gave a particular section to the question of land in the coast, but BBI still wants to revisit that. So the question here becomes, why not, and the person who raised this is quite right, why not simply go back and implement what has already been agreed before? So, and this is part and parcel of the BBI politics. So one might make the conclusion that in fact, BBI is supposed to keep people, ordinary citizens, Wanjiku, thinking that herein lies the solution, while in fact, BBI is helping the elite to continue to cover up the issues that have negatively affected the lives of citizens. So I agree totally with that concern, and this is one of the key questions that we must engage with. At the end of the day, I suspect even the referendum bill might just recycle some of the things that we've already had in different reports and in the Constitution itself. Thank you.
Yeah, and just to join on that, I mean, we have a proposal in the legislative framework which talks about a neutral umpire in the name of the commission being now empowered to redraw a legislative proposal. I mean, if it is a popular initiative, the person backing this popular initiative must have done their own needs assessment and come up with their own legislation. How do you feel about allowing the neutral umpire to actually have authority over the final output of a legislative referendum question? We have the IEBC as the referee and also a player in the relation of being empowered to consult the Attorney General and the National Assembly and the Senate to actually redraw the thoughts of a popular initiative. What are your thoughts on that, Maurice? I am curious to just hear what you think about that.
I think it must be one of the issues that I also alluded to, and it's good also that you bring up the whole IEBC issue. So the first is just the concern that you have raised, that this is the umpire. It receives, you know, the bill and then is given this power to actually rewrite it. I think, you know, they don't use that language, but I think that is what the IBC then is being told. If you look at our politics, the IBC has been a very critical player in terms of the distribution of power, and particularly so at the presidential level. So one ought then to be very careful about this kind of provision, because what it might mean is that the drafters of this bill are looking at a situation where the IBC can become a tool in the politics, that the IBC can be instrumentalized to make sure that, say, if you are Aukot, for example, you are an outlier, you are not a major political player, and you've written, you've come up with a bill, then IBC, which is supposed to be the umpire, then actually has the opportunity to change what you have done. And it doesn't even seem to suggest that you will have further input in that. Now, the second thing I want to bring up on the IBC and reflecting on BBI report number 1 is that actually the current IBC is supposed to be done away with. Now, you see, there's this contradiction that on the one hand, we constantly want to demolish the electoral body, but here now, on the other hand, you actually want to suggest that you have a lot of faith in that very same body, which really sort of just plays within the politics that we have discussed, that key political players in this country will always want to instrumentalize the IBC. So if the IBC is not delivering some desired outcomes, then there is need to demolish it. So we will continue to shape the IBC so that it is in line with desires of the dominant political forces. Let's just consider for a while that we want to go back to the system we have tried before, where the commissioners are actually nominated, appointed, I don't know where the line is there, by political parties. We've tried this before. We've tried this before. And the fact that we demolished IEBC, the electoral body then, basically means that were not satisfied with that. So we are going back to that very system which we had already demolished before. So you see, there's a lot of contradiction here, particularly if you start looking at the electoral body. And yes, so I agree that the referee cannot then be given certain powers which can be used to sabotage a referendum process if the dominant political forces do not like it.
Yeah, that's a very in-depth analysis. And the question is also coming up, Maurice. What are your thoughts in relation to the adequacy or lack thereof in addressing the question of this interesting context of we are now empowering citizenry and the commission itself, which also participated in drafting the legislation, to question the process and also conducted the process. They're now empowered to also question the process. A specific crop of citizenry has also been highlighted as registered voters, and for the persons at the time being having the capacity to vote and registered as such, are empowered to petition the High Court in relation to the outcome of a referendum process. Do you feel that some of these proposals, we're talking about what you've highlighted in relation to security for costs of about £1 million in relation to the petition around a referendum question, we're talking about the mandatory publication of your petition within the specific Kenya Gazette and at least one local daily? Are we talking about the ability to petition the outcome of a referendum being limited? And also, if you're talking about questions affecting the Bill of Rights specifically, does it mean that then the ordinary mwananchi who is actually going to have an impact, a general impact in relation to the change in the Bill of Rights, will not have capacity to access the question of questioning the sanctity and the validity of that process? As you go into that also, we have a question from Mercy, who is asking, we're talking about public participation as a national value. Does the bill provide the county assembly? The bill provides that the county assembly will give notice and, of 2 newspapers with nationwide circulation. Is this really enough scope for public participation and feedback at the same? And also, do you think we have enough provisions? Because you came up with this point and it's good you just do a joinder. Do you think we have enough provisions for, because publication is one thing, civic education is a completely different thing. Do we have enough provision to ensure that there is civic education? Because at county level, a simple majority means that an assembly with 18 people can still pass a constitutional amendment bill with 8 members. Do these members have adequate resources to conduct civic education? Is this period that is suggested under Section 5 enough to actually have adequate and proper public participation with clear feedback mechanism from the ground? And also, please just address the question of how is it that the county is allowed to debate and also the county is hands tied on a yes or no? The county cannot give input and say, fine, we feel that this proposal is okay to the extent that it is reviewed to appear as such, because these are the aspirations of the people of our specific county. Kindly just give input on that as we proceed. Thank you.
Okay, thanks a lot again, Peter. So let me just start from the last issue that you raised, and I think these are some of the very important weaknesses that even Philip had highlighted earlier, and I think I also made reference to this. So so the role of the county, as you say correctly, the county also can either accept or reject. That already tells you that there's very limited scope in terms of dealing with individual issues. And herein, you find quite a problem. The thinking behind counties is partly that there are certain issues that are of unique interest to certain counties and certain regions. And if I'm seated at the county assembly, I'll be asking myself that this bill, what exactly does it portend for my county? Of what interest is it to the residents in my county? That is how I look at it. If you're asking me to either accept it or reject it, because I represent the interests of the counties and so on. So you realize then that, again, the scope here to question individual suggestions, particularly in the event that you have a multiple a multiple question referendum then becomes very, very limited. And that also percolates to the citizens at the county level. So if I go to the other concern, is whether we have enough provisions to enable citizens to even understand what is going on. And whereas the counties have the mandate to carry out, so there's mandate in two ways here. The counties, first of all, have a mandate to carry out civic education. We know through our interactions with counties that the capacity to do that is extremely low. We've seen, perhaps with Makueni being an exemplary case. I've looked at different counties and how they've implemented the mechanisms of participation. And you find that a lot of the infrastructure is actually not there. A lot of the counties do not even have the mother public participation law in place. A lot of the counties have not configured the infrastructure to carry out continuous civic education, which is actually a mandate of the counties. And then the second limb of this is the voter education aspect, which I think the referendum bill we are discussing here also reinforces as a mandate of the Electoral Commission. And I may have forgotten to say this, but the Electoral Commission usually works with other parties, and I think that is something that probably also needs to be reflected therein. Because also the capacity of the Electoral Commission to conduct proper voter education has also been found to be fairly limited, and so on. So in response to the question whether we have enough provisions, absolutely not. And this is a major point of weakness. The way the referendum bill comes out is it's going to limit a lot of players. It's going to limit Wanjiku, who is expected to vote for at the referendum. Is going to limit the counties in terms of the leverage they have to look for and support questions that are relevant to them, and so on and so forth. So if I, Peter, if I proceed to whether public participation is a national value, and the provision of publishing at the county level using the Gazette and the newspaper, the newspaper, 2 papers of national circulation. I think my earlier point was that, you shouldn't ask counties to publish in national newspapers, because you will end up with 47 counties publishing the same in national newspapers. So perhaps this could be taken to the commission, but the counties should retain the role of advertising in the Gazette, because the Gazette circulates within within the county. Now, I think everything I've talked about seems to suggest limitations in terms of public participation, and particularly so at the level of Wanjiku. And again, let's not forget that this takes us back to the politics of BBI. You remember when the BBI Report 1 was launched, and there was a suggestion at Bomas that citizens would get copies of the BBI report. That never happened. The next thing we saw was BBI rallies and so on. So one must really look at all these issues and connect them. That it might be the case that this bill has been deliberately made weak in terms of facilitating Wanjiku, so that the voice of Wanjiku actually does not get to be the one being listened to and being in charge of this process. So it is very possible, from my own interpretation, if you look at the whole discussion and how it has happened, it is very possible that this is being done deliberately so that the voice of Mwananchi continues to be suppressed. The other issue that came up is on the Bill of Rights. Let me just start with the question of the issue of empowering the citizens. In this case, can citizens actually be petitioners? We have seen this in regard to other petitions in the electoral process, that there's a constant attempt to to have this high threshold, particularly in regard to material endowment that the ordinary citizen cannot reach, so that in a certain manner, we are defining certain political processes to be basically as a function of class and wealth. I think there's a very heavy, whatever one pays when they want to vie for presidency, when you want to vie for governorship, and so on. And these have been questions of interrogation over the years, because in a way, we are already curtailing the ability of those who do not have these material possessions to actually take part in certain political processes. I think what I've not seen, and this for HakiJamii and its partners and others, is a consistent challenge to this evolving culture. That, if you want to be president and you don't have a certain amount of money, you cannot make it. If now in this case, if you want to lodge a petition and you don't have a certain amount of money, then you cannot do it. So certain political processes in this country are being defined from a class and a wealth perspective. And I think we need to consistently challenge this, because it's going to continue coming up as we go on. I think, Peter, I've responded to the questions that you raised. Please, you'll remind me if there's anyone that I've left out.
Yeah, thank you very much, Maurice. I think you've been able to comprehensively address the questions that were posed. I would like to just submit another question directed to you by Daisy, just making a reference to how the state has decided to bulldoze the questions and issues around the BBI. Her position is simply seeking to understand, is it possible to, I'll take one half of the question, and then maybe I'll let you give a joinder on the second as we proceed. So she asks whether the BBI process, since it has already spent public resources, is it possible to challenge it in court? And then, given the obvious reality that the state has decided to descend on people who do not agree or support the BBI process, what does this mean? I think you can just tell us, based on the current attitude that the government is having, what does this particular legislative proposal and the BBI process, as the BBI 2 is coming in, and the referendum that is impending, what does it mean for ordinary citizens? And then she seeks to understand that is there a possibility of bulldozing this agenda, and gives an example of the abolishing of the Nairobi County and in place of the Nairobi Metropolitan Authority, and gives an example of the dubious instruments. I think the reference is to the deed that was signed between the national government and the county government of Nairobi. And also it's the national government's refusal to swear in the 41 judges, weakening the independence of institutions. She then states that we have also seen some of the BBI proposals in the Miscellaneous Amendment Bill of 2020 with 2 years to finish some of these corruption cases. I would like to address myself to the question of whether the BBI process can be challenged. I mean, it is on record that one of the activists has actually made an application to court to just challenge the validity of the whole process. Okiya Omtata approached the court and made an application to question the establishment of the BBI task force, and also being gazetted as and allowed to spend public resources. Of course, for issues of sub judice, we would be able to delve into the subject since it's still pending determination before court. And I would also seek to address the question of whether the government can be able to sneak in some of these proposals based on how they're acting. Of course, there has been a challenge also as to the validity of the establishment of the Nairobi Metropolitan Authority by the LSK. And from my own understanding and reading of Article 255 through to 257, I mean, the question of abolishing a county has to be set to a referendum. And some of these provisions can only actually just be put in by the state through other, as you've rightly put it, through other legislations to reinforce already existing institutions. So ideally, for the questions highlighted under Article 255, the state can only do what Maurice is highlighting, which is actually create a very weak framework for management of a referendum and sneak through a universal suffrage question by popular vote through a framework that is very weak to ensure that the outcome favors them. So, and that is actually one of the risks that we stand to face if this particular bill goes through as is without a very good and strong deliberate input from the civil society. So maybe Maurice, as you can also just make a comment onto what it means in relation to constitutionalism, what it means for the ordinary citizen, that the government is very determined to make some of these changes and has already gone a further step to actually, I don't know if forcefully is the correct word, but they have been able to use the executive orders. I don't know the place of executive orders in our current constitution. You can also try and address that. They've been able to use several dubious legislative amendments, and they've been able to actually start implementing some of these projections within the BBI. And a good example is what is happening to Nairobi County. And of course, its environs, because the Metropolitan Authority spreads to Machakos, it spreads to Kajiado, it spreads to Kiambu. So kindly just tell us, what does this mean for the sanctity of the Constitution? What does it mean for the small Kenyan who does not have a direct line to be able to petition these changes and actually demand justice in relation to these breaches by the government? And do you think that there is a very high risk of affecting the sanctity of the Constitution if we make it too simple that any citizen can be able, as you've put it, it's very resource driven as in most provisions. I mean, we're talking about 1 million, we're talking about advertisement. Do you think there's a real danger in making it possible for all Kenyans to petition and challenge and just speak out in relation to what is happening to the Constitution to the extent of mutilation?
Thank you. I mean, starting with the last issue you've posed, I think the Constitution the Constitution gives every citizen the right to participate in these processes. For me, I have no doubt in my mind that a lot of these attempts to limit participation, if properly challenged, will be found to be unconstitutional. And that's why I'm saying we ought to have processes where we constantly challenge some of these, the things that the executive does many times that we think go against the Constitution. But at the same time also in regard to the bill we are discussing, in regard to elections, in regard to fees that are paid at IBC. I've gone through a lot of these processes with a number of people. You have persons living with disabilities. Some of them the system have oppressed them for many years. They have not had jobs and so on. And here someone wants to vie, they have to start negotiating with political parties. They have to start negotiating. So, it's sort of part of this criminalization of poverty, that if one is poor or one does not have a certain threshold of material resources, then their rights are taken away. And this is something I think we need to constantly challenge. Broadly, whatever its manifestations in time and place. I think this is something we ought to constantly bring to question and constantly challenge. I like the fact that you give the example of Nairobi Metropolitan Services. I'm one of those who have been engaged in that. I made an attempt to petition the Senate on what should happen, and the fact that at that point, even before the court said something, I think some 2-3 weeks ago, my position was that that process would be adjudged to have been unconstitutional. I must say I've not read what the court exactly said, but the BBI had already said that Nairobi ought not to be, to be governed the way other counties are governed. The example, I think, where they're getting their, they're looking at the situation of Abuja. I think Abuja, which is under directly under national government. I don't know whether it's national or central over there, but actually managed by a minister. So this is the kind of framework that State House and their colleagues are actually looking at. And you know, the challenge has not been, to me, as robust as it ought to have been. I know there's been a court challenge. Our petition to the Senate that time was not lodged. They came up with some technical excuses and so on. But I think the challenge ought to have been more robust. But then again, we are now having a bit of a problem. What the government has done is actually to put a lot of money into Nairobi NMS, and you can see all the infrastructure work that is going on. And I suspect there's also a lot of propaganda around why Nairobi ought not to be governed under a county. So we'll be engaged in this politics for a while, and we ought to have more robust engagements. I think that the point you made, Peter, about the dissolution of a county, you realize that this thing was done in a very clever way. It was done in a very political way, so that they say it is transfer of functions, which is legitimate under the intergovernmental, I think under the Intergovernmental Relations Act. So on the one hand, we know, you know, the intention is not good. It's not an intention of providing housing to Nairobi's informal settlement dwellers. It's an intention to continue capturing and controlling the economy of Nairobi. That is, in essence, that to me is what is going on. And so they cleverly did not dissolve the county. They cleverly said it's a transfer of functions, so that when you challenge, you really have to try and argue that in fact it is not a transfer of functions. I called it a surrender of functions, basically meaning you have more or less dissolved the county. And you can see that some of the key functions of the county are basically now being performed by the NMS, beyond, if you want to believe Sonko, beyond even what was agreed. So this is a very important consideration in this debate, because the moment they succeed with Nairobi, you don't know which other county they are going to target. And it's very clear that counties with high economic potential could very easily fall prey to this kind of shenanigans. Now, and of course, we know Nairobi produces over half of the country's GDP. So clearly the economic interests outlined there are open to, everyone can see that. The questions that were raised by Daisy, that the state has decided to bulldoze. Yes, the state is bulldozing and will continue to bulldoze. And I think partly, if this is the Daisy I know, partly our reaction as civil society has not been robust. I was left only to go to public and say we need civic education, but we needed a more robust debate on BBI. For those who know, I personally made efforts to come up with a platform, referendum debate platform, thinking that that would seize the moment and people would be happy to engage in the debate, either in support or in opposition. But nothing really seems to be happening in this country at the moment after the handshake. You know, it's almost like 99% of citizens now believe that whatever Uhuru and Raila cook up in their sitting rooms and bedrooms is good for this country. So we have fairly serious challenges, even as activists, and what we can be able to achieve. You know, the initiative has spent public resources. There are questions about appropriation, which I think is why Okia, partly why Okia is in court. I'm not sure what that will achieve. I think the state also just happened to have very many ways of hiding expenditures. That does not mean there shouldn't be challenge. I think we must also be aware that a lot of resources that belong to counties have actually gone into the BBI process. Of course, it's very difficult to know because they know how to hide those costs under meetings and stuff like that. So the work for us is actually a great deal if we want to challenge. But you see, my sense is that the rest of the remaining part of this process will be pushed very quickly, and hence the shenanigans going around in Parliament in terms of committees and so on and so forth. So yes, I think we still need, there's still room for a more robust civil society reaction to BBI, but time might not be on our side. Finally, is it possible to challenge? Yes, Peter has already spoken to Okia's a challenge. I don't know how far that will go. But again, as I said, I think we ought to have a more robust challenge. I mean, we are not even able to stand up to just this simple thing of people cannot have their political meetings if you're not supporting BBI. While Atwoli is busy with delegations dancing every day, if you are known to be an opponent of BBI, you cannot meet anywhere. If you are known to be an opponent of the handshake, you cannot meet anywhere. So that's the reality. Unless we can challenge it more robustly, not just in court, but yes, court is a good platform, but you know, courts take forever to decide things. So I think for those who are thinking that the BBI portends a serious threat to the Bill of Rights, possibly a threat to it can even bring down some of the very good provisions we have for public accountability. For those who think that way, then my personal thinking is that we still need to very robustly challenge the process and the outcome that will come out of it. Let me just mention that in a past analysis that I did for Freedom House when I was the regional director, I pointed out something very interesting, which seems to be happening now, that the only person with the political muscle to go against Raila and Uhuru is actually Ruto. And many people are not happy with me for saying that. But where are we now? We are exactly at that spot. I am almost sure that one day you'll hear Yashpal Gai saying, please Ruto, help us from these guys. But that's on a light note. Thank you.
And I think you bring across a very important point, because we've seen instances where the court has pronounced himself on the constitutionality of the NMS, for instance, and the DG is still operating, is still running around on public resources, implementing the agenda and actually doing whatever it is that the unconstitutional office is supposed to be doing. So ideally, I just joined on what you're saying. I mean, it calls upon practitioners, the civil society, to actually speak up in a better and louder voice to say, we have a government that it has no respect for the judiciary as an institution. An order is passed and there is no attempt whatsoever for reparation to actually respond to the declaration that an executive action is unconstitutional. So we're in a catch-22 where, so now we've gone to court. So what next? And that's a very interesting situation to be in. I'd like to open this up a bit to the panelists to just give in their closing remarks. Participants as well, feel free to raise your hand and make a contribution as we gear towards the close of this webinar. Of course, I will be seeking to circulate all the presentations that have been made within this forum, as well as the draft memorandum for input to the legislative proposal. So, Maurice, you want to go first? Give your joinder, give your closing remarks. What recommendation would you want us to make sure sees the light of day within the memoranda? And what are the options that we have? If, of course, as you put it, we need someone with enough muscle. Are the people holding sufficient muscle to challenge the current status quo? Because we are in a government that has simply just disregards institutions. It's just the executive and the rest of us. Kindly give your joinder.
Yes, Peter, the situation certainly doesn't look good. And this has been so, I think, since 2013, if you remember, our struggles with the Public Benefits Organizations Act and its implementation since 2013, with I think some 2 court orders which were ignored, and so on. So yes, the the situation certainly doesn't look very good. I am a believer in I always believe that when two people put their heads together, they can think better than the one person. And so I always have this feeling that if people engage more, we can always come up with ways and means of trying to reassert the influence of citizens and civil society on governance. I've seen that there has been some organizing around Sabasaba. Sabasaba must be tomorrow. I do not know. I only saw that some communications over the weekend. So I don't know whether Sabasaba is going to articulate some of these questions. Certainly, we need that kind of organizing. We need people who can say COVID-19 or no COVID-19. We are going to hold protests. And we are not going to ask for permission because that is not what the law requires, and so on and so forth. So I think we ought to think outside the box. I certainly can't myself claim to have all the answers. I think civil society ought to go back to the kind of organizing and thinking processes that we've done in yesteryears. If we were able to bring down Kanu, the Mugumo tree, I suspect the current situation is not such a big challenge. It's only that a lot of activists now are not socialized to this kind of things. We had a period during the Kibaki years when a lot of those who joined activism found a situation where you wake up today morning and at 1 you have an unplanned demo in the middle of Nairobi, and we did a lot of that. But that socialization now is hitting us because we seem to have forgotten how to behave in situations of authoritarianism, like what used to happen in the 80s and early 90s. So I think there's need for a new kind of thinking in the sector. We need to go back and say, how exactly were we able to defeat the one party, very well grounded one party system, and so on. Now, I think we ought to, if we're looking at this from an advocacy perspective, then we just ought to be aware of the processes. And I think that has been very well addressed in this meeting. That one, we are going to have the second BBI report, which I suppose is just awaiting, handover to the president and the former prime minister. So very quickly, we have to look at that. We have to burn the midnight oil, get to understand what it's all about, compare it to the first report. We do things the way, I remember, Peter, if I may just allude to this, on 17th November, 2009, we had the first draft constitution from the committee of experts. And that day, as we were receiving the draft at KICC, we were on our way to Machakos for 2 days to analyze it. So, that kind of preparation, so that, whenever something comes, you are ready. The infrastructure for analysis, the infrastructure for deciding which are the suitable responses is already in place. You're not waiting for the thing to happen, then people start calling each other and wondering what to do or what has hit us. So I think we ought to then think that way. Very quickly, we have to analyze that report, the same way we're analyzing the referendum bill. Very quickly, we have to be aware of the processes that will happen after that. We have to think of those committees. How can you then begin to also influence the kind of people who will go to those committees? People like Odhiambo now are always volunteering. So if you guys want to lobby and so on, to have some of us in those spaces, we can always see what time we have to be in those spaces, so that then the kind of issues that you have can then percolate to those spaces. Finally, just to finish with the issue of commissions, I know commissions are addressed a little bit in the BBI report 1, but I'm waiting to see what will happen with BBI report 2. And we ought at this point to ourselves as civil society take stock of what has happened to commissions. Partly the fact that commissions have more or less degenerated to employment bureaus. They are no longer as robust as they used to be. If you go back to 2011, 2012, 2013, we seem to have lost a lot there. And the question whether you still need the same infrastructure or what to do. What do you do to make these commissions more proactive? We know, for example, and usually we discuss this with people in these commissions. IPOA, for example, if you look at the last appointment of the guys at the top, you find that it was really driven by political interests. This is happening across the board now. We are going to have commissions which are supposed to protect the sovereignty of Kenyans, which will now, you will have things like the Burundi Human Rights Commission, the others in Rwanda and so on, which wait for government to give a position. Then they run all over town saying this is the right position. So ladies and gentlemen, I think I want to stop there. There are broader issues of discussion, obviously. And HakiJamii, Peter, I have my contacts, whoever would want to continue these debates. I'm always available for that. Thank you.
Thank you very much for that, Maurice. I mean, you bring in very interesting aspects of constitutional commissions meant for the safeguard and protection of this constitution becoming a reward mechanism for political cronies, and thus losing the luster that they're supposed to have in relation to addressing the safeguard of this particular constitution. And that's something that has also been alluded to and needs to be addressed very intentionally by the civil society, practitioners in the human rights space, and citizens in the country as well. I'd like to invite Pauline to also give her joinder and her closing remarks as we gear to a close of this webinar. Pauline?
Thank you very much, Maurice, Peter, and also Philip for being with us during this discussion. I think our participants, you can agree with me, we had a very well-versed panel that was able to address some of the issues that are coming up in the referendum bill. And as part of the next steps, HakiJamii will submit a memo in this regard, and we'll see how best to continue engaging in the process. And also just to look at what comes out of BBI 2 report, because as I stated in my opening remarks, we have just the electoral injustices being addressed and not the socioeconomic rights injustices that have really been part of the major problem of Kenyans. Be it lack of basic services to informal settlements and so forth and so on. We've politicked too much. Yes, the constitution is very heavy on the rights language, but so far we've not been able to operationalize Article 43. We had the dignity bill that was discussed in Parliament a while ago. It went to the Senate and it's still not become a law to date. So housing rights are given to us like tokens. It's part of the Big Four agenda. Today it's there, tomorrow it's not there. We're not very, very sure on whether the most marginalized people in the society will be able to benefit from all the policies, from all the legislations that happen. Public participation clearly has become, an elitist component when it comes to policy enactment. So how do we bring that back? So as we keep thinking about the referendum bill, we'll really be grateful if you could send your comments to my colleague, even post this discussion, because we will have that memorandum, we will share it with the public, we'll put it on our website and our social media accounts for us to continue engaging. So thank you all. Thank you very much for your patience and for your contributions. I see you all who are here, and we hope to continue engaging more in the next coming weeks. And stay home if possible, stay safe, and see you all very soon again. Thanks.
Mine is just to appreciate all participants who made time. Thank you very much, Pauline, for those very elaborate remarks of closing this webinar for us. Just to also reiterate our commitment to circulate this memorandum for comments as well, and just give your input as much as you can and enrich it as much as you can, because any legislation that has a direct bearing on the Constitution directly affects you. Thank you very much for making time. Until next time, asanteni.